Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, we're a couple minutes early, so we always have a big, multi-million people watching us on streaming. So we'll wait till actually 9 o'clock, so we don't get accused of doing something and starting early to do something. Get everything straight here. Aaron, you're running the clock?
Yes, sir.
I don't have any pushing things here. For 11 years, I figured out how to work the clock, and they take away from me. Okay, it's like it's 9 o'clock, so good morning. Welcome to another session of the oral argument with the 5th District Court of Appeal. We're here today in Flagler County, Winnell County seat. Happy to be here. We appreciate the invitation and glad to get out and visit with the counties in our and the distant circuits within our district. We do this on a fairly regular basis. We've been here for a while in Flagler County. I don't think we've been actually at this courthouse. No, at least not 11 years that I've been here. So, okay, let me introduce the panel that I've been introduced. I'm Brian Lambert. I'm the judge presiding over the cases of this morning. To my right and to your left is Judge Eric Eisnagel, and to my left and your right is Judge John McIver. This is kind of a heads up. I don't know if anybody's here for the third case. We are going to take a break after the second case. We're going to have a panel change on the third case, so we'll take 5 minutes to make that adjustment. A couple things. We are being live streamed, so if you have any phones that are in the on position, please either mute them or turn them off, or any other electronic devices so that they don't inadvertently go off and interfere with the oral arguments of the attorneys. We do have 3 cases here today. First, each side will have 20 minutes. We will set a rebuttal amount of time for 5 minutes. If the appellant would like something different than that amount of time, please let us know. Our Marshal Aaron over there will set the clock accordingly. You'll see at the podium, the light will go off once you get into your rebuttal time. The yellow light will go off. And use as much of that as you want. I will let you know that you're in your rebuttal time. You don't get aggregating at 20 minutes total, so how you divide it is your choice. The red light will go off when you use that your time. Okay, that being said, our first case this morning is case number 23-3589, Valerie Neal versus State of Florida.
Laura Sapir on behalf of appellant Valerie Neal. May it please the court?
5 minutes.
Yes. So we're here today for 6 grounds of relief. And I wanted to focus primarily on ground 1, which concerns the judgment of acquittal argument as it relates to grand theft. And to be frank here, there wasn't a crime here. Perhaps a business dispute, maybe an employment dispute, maybe even a tort, but there wasn't a crime. And the primary reason for that is that you can't have a property interest or ownership over prospective profits. And Cabinet Factory never obtained any interest over those profits. And the main reason for that is because the check was written to Whittlefish. And when they handed a check to Whittlefish to Valerie Neal, there was no exchange with Cabinet Factory. It was to Valerie Neal. It was clearly written out to Whittlefish. Therefore, she
wrote out one of the checks.
Yes, but at the consent of the customer, and the customer signed it. So they both knew that it was going to Whittlefish. Whether they thought Whittlefish had some kind of connection with Cabinet Factory, it made no difference as to whether Cabinet Factory obtained ownership or property.
Why is that? Why does that not matter then? The testimony was, at least for one of the customers, seemed pretty clear that at least one of the customers, perhaps both, thought that they were closing a transaction with CFO.
Well, they may have thought that. However, the question is whether it became the property of Cabinet Factory. So whatever they thought, they wrote down Whittlefish and they handed it to her. And at that point, it was never handed to Cabinet Factory. At that point, she wasn't acting as an agent.
But they were in. So can I call Cabinet Factory CFO? Is that fine?
That's fine.
You know what I'm saying. So they were in a CFO store or building.
Yes.
Your client was an employee of CFO, correct?
Yes.
Right?
Yes.
Your client didn't say, hey, I can get you a better deal from a totally different company. Call me after hours. Here's my card. Right? Nothing like that.
Yes.
Transaction proceeded during CFO's business hours with an employee of CFO, correct?
Yes.
And at least the customers said, hey, we thought we were closing a transaction with CFO, right? Correct.
Yes.
Okay. So why is it stealing? I mean, by the way, I think it's a fair argument to raise. I think it certainly is an interesting. You don't see this in every criminal case, right? It's certainly an interesting issue. And wouldn't your argument be far stronger had your client said, hey, you can get a better deal with Whittlefish. That's a totally different company. Here's the card. Call me at 7 tonight.
I mean, yes, it could be a stronger argument when there's a factual dispute in front of the jury, which would be some of them said they didn't think that, but she said that they did. She told them that. But as far as JOA, I think, again, it's the legal issue of whether they actually obtained that money. And they didn't. They just didn't. It was written out to Whittle check.
What if it was written out to cash?
I think that could be more of a fact question. I think if there was testimony still that you're getting these cabinets from Whittlefish, that would still be in the same
But
way.
the testimony is, I thought the two customers, I thought I was working with CFO. I'm in the CFO building. I consummate the transaction today. I give the check. This lady is a CFO employee.
I mean, I think that's just belied by the fact that the check says Whittlefish. I mean,
Why can't a company work and close transactions under more than one business name or even more than one company? Why can't it have a subsidiary that they regulate, or even just a joint venture with another company? Why does that necessarily indicate that it's a completely separate entity and company, and that the transaction's completely separate?
well, I think, one reason why the transaction is separate is because the countertops and if they bought anything else were a separate transaction. Those amounts weren't including the check. The checks were just for the cabinets.
But again, I mean, why would the customer know that, right? I mean, CFO is perfectly, or wouldn't they be free to have a subsidiary called Whittlefish?
Yes.
That they have a separate account and they say, well, the way we're going to do business is our subsidiary called Whittlefish is going to do the cabinets, and CFO will. And I mean, why should we care how they conduct their business? Why is that impossible? That's, I guess, what I'm saying.
I don't think it is impossible, but I think I'm not sure that it makes a difference in this case.
I'm not super clear on this. What exactly do both CFO and Whittlefish do as their business? They don't manufacture the cabinets, do they?
I don't believe so. I think
So
it's
they're
kind of like
getting them from another
outlet.
vendor, they're being delivered, someone's installing them. Do CFO and or Whittlefish do the installation?
I believe so. I know Whittlefish in this case installed at least one of the customers.
So they installed it, is that what you said?
I believe it was the fiance.
Okay, so they didn't use the services of CFO to do the installation. CFO didn't do the manufacturing. The equipment that they bought, the material that they bought, didn't necessarily come from CFO. CFO and Whittlefish are both essentially pass-through companies.
Yes. Like where else?
So I guess one distinction I potentially see is I think that your argument would be quite a bit stronger if if we view this as truly the classic stealing a customer.
Yes.
Because that starts looking like a business tort or that sort of
Yes.
thing, right? Something maybe you get fired for, maybe you even get sued in civil court for, right?
Yes.
And I think that's essentially what you're saying this is.
Yes.
Fair enough. Is it a fair distinction to say that, well, stealing a transaction might be a different thing altogether? Stealing a customer, right? Hey, customer, I can get you a better deal. Call me at 7, totally different company. Here's the card. Versus, yeah, CFO can do this for you, absolutely. And then just having the customer think that they're closing the transaction with CFO, having that intent, and then sort of stealing the transaction as opposed to stealing the customer.
Yeah, I could see that. I just think that in this case, what happened here is that they didn't steal the transaction. There were terms as to CFO can get it to you in a couple months or whatever it was. We can get it to you in a week. So I think it still goes to that where it's stealing the customer, not stealing the transaction.
I mean, there was certainly evidence that the jury could have concluded that the customer knew that Whittlefish was a totally different company and that they were not closing a transaction with CFO, right? There was evidence that the jury could have, but that doesn't. But there was also evidence. You agree? There was also evidence the jury could have concluded the opposite.
Yes, but I still think it's the legal issue of whether you can own prospective profits or whether you can have a property interest over prospective profits. You can have a property interest over profits, but I think at that point it was still prospective. When she said, I have different terms for this, I can get it to you faster, write Whittlefish on the check. At that point it was prospective, and they never closed the deal with Cabinet Factory.
So you just don't think it's relevant that the customers thought that they were closing a deal with CFO? Correct.
I think that it's a legal issue of whether Cabinet Factory could have a property interest over prospective.
So what's dispositive in your view is the two words Whittlefish. Obviously the check said CFO, the check said cash, or it was just they gave a blank check. In the old days, people, did you have a stamp? Does it stamp somebody's name? So, I would have to write out the full thing on that. That's probably 80s. I don't write checks. I don't write it. My wife does that.
Yeah, I didn't ever do that.
So I mean, that your whole position is because the words Whittlefish are on these two checks.
Yes.
At that point, whether she was misbehaving as a CFO employee, that's in civil court between CFO and her, which did happen, apparently. Yes, she got fired, etc.
Yes, the fact that it was made payable to Whittlefish, that deletes any ambiguity.
Hold on. What if she said, Whittlefish is a subsidiary of CFO, and that if we go through the Whittlefish subsidiary of CFO, you'll get these cabinets sooner. Write Whittlefish on the check. So Whittlefish is on the check now.
Yes. I mean, if they were adamant about perhaps getting it from a subsidiary of Cabinet Factory, I think that might make the difference. But at the end of the day, the check, they know it's going to, let's say, this subsidiary. I still think it's the same thing.
Well, I guess let's take it out. So you're at Home Depot, and I'm going through the checkout thing, and I'm going to write a check, and I've got my stuff with me out of this Home Depot place. They didn't make it. They didn't make the lumber. However they got the lumber, they're not selling it. And the person helping me through the checkout, the self-checkout, because I'm an idiot, I don't know how to use it, all of which is accurate. I do that, and that person says, just write it out to, Home Depot or Happy Depot or something like that. So, and I'm thinking, I got a project to do. My wife wants me to do this project. I don't care if I make this out to Osama bin Laden. Have a nice day. I'm walking out of here. I think I'm dealing with Home Depot. I bought this stuff from Home Depot, and then it turns out that these guys now want to prosecute that. I as a customer, think I'm dealing with Home Depot. I'm in the Home Depot building. You're let me reiterate. I mean, you're basically saying because I then write the check, however they tell me to write the check, that their Home Depot hasn't lost anything by their customers, by their employees.
Well, I do think that that's a weaker case, but I think here what issues make it different is that there was a discussion of cabinet factory can get it to you in this time period. I can get it to you through this company in a shorter time period, and I believe there's some testimony that it's a little bit cheaper. So it's not the same. It's not like you walked up to Cabinet Factory carrying the cabinets.
But the customers don't think they're dealing with a company called Will. They both were, especially Ms. McClary. I mean, I thought I was dealing with CFO. And that's who I thought it all from the get-go. Here I am. All right, somebody wanted to check for Whittlefish. I'm out of here. I'm getting my cabinets. That lady said she's going to get them to me faster. Good. I'm suffering from a hurricane damage. That's great.
I think there's another distinguishing factor too, is that they didn't get Cabinet Factory cabinets. They got cabinets. Ms. Neal provided the cabinets. It's not like she took Cabinet Factories and brought it to her house and installed it. She provided the cabinets too. So I think in the scenario, if you pick up stuff at Home Depot, I think it's different.
I want to be sure I'm clear that I understand what you conveyed, especially to Judge Eisenhower's hypothetical of, what if she plainly said, hey, we're a subsidiary and completely misled the customer. If we ignore all of the other factual, frankly, distractions in this case from the legal question, you had said that still wouldn't have met the elements of this crime. You didn't say that it wouldn't be any crime. She might be guilty in that case of fraud or maybe even timesheet fraud or something along those lines. All you're saying is she wouldn't have met the elements of grand theft because there was no property interest.
Correct. If we don't have any other questions on ground one, I wanted to move a little bit out of order to ground 4, which concerns an improper legal conclusion by the detective. And I'll just concede from the get-go with page 259 where he made a statement, checks were written to her personal business, depriving Cabinet Factory outlet. I do agree that's not preserved. There wasn't a contemporary objection to that. But I do think it's relevant in determining prejudice, what the harm was in this case. And then I would also point to page 264, 265, where the question is, what makes the actions of the defendant in this case criminal in nature? There was some sidebar about that, and then 266 to 268 asked essentially the same question, what is the nature of the information you needed to uncover to determine if the defendant had actually committed a crime? And the detective answers, whether or not they were doing business with Ms. Neal or Cabinet Factory, whether or not throughout the interaction they knew that they were separate entities. And then there's another question, why is that information in particular important? To which the detective answers, if they believed throughout their interaction that they were interacting solely with an employee of CFO, representing CFO and CFO's interest, and that they were buying a CFO product, and that's what they desired to purchase, by diverting their money to her business, she is taking profit from Cabinet Factory. And I think the answers here are legally incorrect. It suggests that their intent, and our position is that their intent on who they were getting the cabinets from is not relevant to the issue of whether it was a theft or whether they deprived Cabinet Factory of the profit. And I mean, the detective says it right out, by diverting money to her business, she is taking profit from Cabinet Factory. So he's telling the jury that the deprivation element is met, and that's an improper legal conclusion.
Is that the objection that was raised?
I believe so. 266, 268, just before they asked the question, they asked one question and then they had a sidebar, and that sidebar, it was calls for legal conclusion, speculation, invades the province of the jury. And then the state was permitted to ask essentially the same question when the answer came out. So yes, I believe it's preserved.
You're going to rebuttal if you want to keep going.
Okay. I'll reserve for rebuttal. Thank you.
Good morning. My name is Robert Bradford. I represent the state of Florida this morning. With respect to the first issue, I think it's important to remember a few things. First of all of the cases cited by appellant in the initial brief rest on the appellant's testimony and the appellant's version of events, which, as the court knows, conflicts significantly with the testimony of the two customers, Purcell and Cleary.
Did you file the wrong? Not you. Did the state file the wrong charge?
No, I don't think so.
Why not?
Because theft is an all-encompassing type of crime. In the Eisenhower case, which I cited in the brief, this court basically said it doesn't matter how the property is taken anymore. The definitions of theft encompass all the larceny, stealing, fraud, misrepresentation, false pretenses, all those.
The key question, though, is you have to own the property.
Correct. Yes.
Getting to that issue, their argument is certainly that the transaction was interdicted before it became their property. Yours is that the transaction was completed. Albeit, I think their argument is it wasn't completed with CFO. So I think you need to clarify that for us.
I do, and I will. I think it's important that the appellant certainly wants this court to look at the Purcell transaction individually, wants to look at the McCleary transaction individually. I think it's important for this court to kind of step back and look at the bigger picture and stop focusing on the trees and look more at the forest.
I think we need to focus on the elements.
We do, and this is how I'm going to get there, Attorney, please. If the court looks at this as she worked there for 2 years, her business, her Whittlefish business, existed prior to her going to work for CFO. She worked there for 2 years. CFO's policy, true or not, I don't know if it was true or not, I don't think that came out, was that the customers didn't get delivery of their cabinets for 8 to 10 weeks. It's a long time. Now, in this particular case, I think she would have a stronger argument if she told that to the customers right up front and said, hang on a second, before we go through all this process, before we take the measurements and we do the estimates and we do all that, you need to know you're not going to get these things for 2.5 months. And at that point, they can turn around and say, I'm not even going to consider that, and that's fine. And then she could maybe, I don't know, offer an alternative, or call them later and offer an alternative, or they can call her later and she can give them an alternative. That would be a stronger case. But she's waiting until they've gone through the measurement process, they've gotten the estimates, they've picked out the cabinets that they like, the other accessories, whether they're doing countertops or hardware for the cabinets, whatever it is. And then at the very end, when it's time to sign, when the negotiations have completed, she says, oh, by the way, you're not going to get your cabinets for 10 weeks. Well, that's not good enough. Hey, I got this other alternative for you.
At that point in time, the customer who's purchasing the cabinets isn't contractually bound to anything. They haven't turned over any money. They can walk away at any point. So the transaction, the negotiations may have been completed, but the transaction has not been completed. So, if it is interdicted before that transaction is completed, I think you need to tell us how this is CFO's property.
It is because a CFO employee is working in a CFO store, obliged to its employer to sell CFO products. And when it comes to that point, and it says, and they wait until the end, don't tell them, let them get ready to buy, okay? Let them get to that point, and we're okay, and then tell them. So they've reached the point where I'm going to do business with CFO. I'm doing business with the CFO customer.
Going to do business.
Yes.
Going to do business. Not have done business.
That emphasizes the signing of the check. And that's why I cited the Beaver case in my brief, because there is value in the ongoing negotiations, in the customer relationship that CFO has with Ms. Purcell and with Ms. McCleary. And that doesn't begin from a legal point of view only when they establish a contract.
Counsel, let's assume for a moment that this panel doesn't buy that argument. and that this panel might conclude that, even up until the 11th hour, before the transaction is completed, that had the defendant said, hey, I'm going to shoot straight with you here. Here's an alternative, has nothing to do with CFO. This is not a CFO transaction, different company. Do you want to order from a different company who can get it to you quicker? Let's assume for a moment this panel would be of the opinion that that's not a crime, or that's at least not what's charged, okay? It doesn't matter that the customers testified that never happened. That what actually happened was they thought the entire time they were closing a transaction with CFO, and that even when they wrote Whittlefish on the check, that they thought they were closing a transaction with CFO. Does that matter and why?
That the customers believe absolutely matters. And then that's what I was
Does it matter because that is evidence that the transaction actually was CFO's transaction?
It was
the customer had an intent to close a transaction with CFO.
Absolutely.
Not with some other company, regardless of what the name is, right? That was their intention. They testified that that's what they were led to believe. They were in a CFO building talking to a CFO employee, right? Is that evidence that the transaction belonged to CFO?
I believe it is. Everybody's expectation is to do business with this customer and CFO. The customer said, I thought I was buying from CFO. I intended to buy. I think it was Ms. Purcell who said, I didn't like the 10-week delay, but I had to make it work. I'd been to Home Depot, I'd been to Lowe's. I didn't like anything they had. I had to make this work.
Does it matter that the diversion, arguably, right, the diversion of the transaction of the money, however you want to look at it, does it matter that the diversion of the money or the transaction occurred before, I guess, the final sort of closing of the transaction, or at least simultaneously with it, right? So you hand over the Whittlefish check. I don't know if that's before we consider the transaction fully closed, or maybe it's simultaneous, but does that matter?
No, I don't think it does. And that's what I was trying to get into earlier. If the court steps back and look at this as a forest instead of each individual tree, it's going to look more like what it was. It was a swindle. It was a complete grift. She worked there for 2 years. Now, whether she went to work there with the idea of doing this or whether this idea came up after that is not relevant. It's not material. She formed the intent to, once she starts seeing customers, I guess, walk out the door because of this delay, she's like, well, I can do something. I can accomplish something that helps them and helps myself, and at least CFO maybe gets the rest of it. They get the countertops, they get the hardware, they get something. They weren't going to get anything. So it's a grift. She's conning everybody here. She's conning the customer. She's conning CFO, and she's putting money in her pocket. Now, and this is why I think she would have a stronger argument if she disclosed all that up front.
And again, we can say she's conning everybody. We can say that she's defrauding everybody. We can say that she's stealing customers. We can say that what she is doing is just in a very generalized way ambiguously wrong. But that's not what we're here about. What we're here about is the essential elements of grand theft. Can you say that was CFO's property? That is the alpha and omega of this case.
When Ms. McCleary wrote out the check, she had reached the point where I want to give my money to CFO. I want to buy products from CFO. I want to do this. This is my intent. This is what I want to do. Appellant comes in and says, no, you're not going to do any of that. I'm going to substitute this in for you at the last minute. And
that's transactions have closed. Had the defendant not done what she did?
I'm sorry, I missed the first part of the question.
Would the transactions have closed with CFO had the defendant not done what she did? In other words,
yes.
Okay.
Purcell said, I had to make this work. That was her testimony. I had to make this work.
Is the fact that we're asking that question, would the transaction have closed, proof in and of itself that the transaction did not close with CFO? If it had, we wouldn't be here. You can't argue that the transaction was completed. At the same time, you argue that the transaction wasn't completed because she stole it.
There's a certain amount of bootstrapping going on here. That's correct. Their focus is there's no legal right. I can do anything I want. As a CFO employee, I can stab my employer in the back. I can dupe these customers. I can do anything I want until they sign on the dotted line. That's not the way this works.
Let me make that argument. That's not
I
right
thought I
all day
had been,
long.
Your Honor. It's the customer's expectation. Okay, they go to CFO. They didn't go to
Customer's
Whitfish.
expectation creates a property.
Counsel, let's say
Coupled with other facts, yes.
let's say the testimony is clear that both customers get on the stand and say, no, if it was 10 weeks, I wasn't gonna close anything. I was gonna keep looking. Let's say the testimony were clear. That's a hypothetical, right? It's not the testimony here, but let's say that's what it was. Is there a theft?
I think the defense has a much stronger argument, and that's why I was going back to.
Well, I mean,
to
in
if
that
the
case-
customer, and I think this addresses your
Well,
question as well.
under my hypothetical, CFO clearly doesn't have a transaction under any circumstance, correct?
Until the customer intends to give the money to CFO, all bets are off.
Right.
But both of the customers in this case said they wanted to deal with CFO. They thought they were. So, if a
Mr.
business,
Selfish didn't know anything about whitefish or whittlefish.
right? One of them said she thought it was like a vendor or something. And these are CFO, Whittlefish. They're both retailers. They don't make the cabinets. To my knowledge, they don't. They both just resell stuff. Just like
Miss Purcell says she didn't tell me she could get the cabinets quicker for her own business. She just so I can get the cabinets quicker.
And I think it's most important, or very important, to consider that one of the witnesses testified, yes, you can give me cabinets quicker. That's what she said. I think it was Purcell who said she offered me cheaper cabinets. I think that's the difference. Now you're no longer trying to overcome a delay problem that might affect, the customer achieving what the customer wants. Now you're simply just undercutting your boss, your employer, to put money in your own pocket. So,
Do you minimum agree? Do you at least concede that the state had to put evidence in front of the jury that at least one of these customers was going to close a transaction with CFO, even without what the defendant did. If the defendant did none of this, that at least one of these customers was going to close a transaction with CFO.
I think the evidence was clear that both of them intended that.
No. I'm saying, do you agree that that's necessary for the state to get a conviction? How is it how is it CFO's transaction if you haven't proven that it was their transaction?
Okay. Again, I think we're asking the same question in a whole lot of different ways, and I understand that, but the answer is the same. CFO expected her to sell CFO products and collect revenue for CFO. The customers went to CFO wanting to see if they had anything, and she apparently talked them into it. So now they expected they were doing business with. I like those cabinets. I want those cabinets. Let's do this. How much do I owe you? Who do I make the check payable to? I mean, if at that point someone can undo all that, an employee of the company can undo all that and take that money intended for the employer and redirect it to herself, if that's not theft, we're all in trouble. Every business in this state is in trouble. It has to be.
Why isn't that closer to stealing a customer? Why is that what you just described? And it may not be, right? I'm not saying it is. Why isn't that just a tort? An actionable tort?
Because she let it get all the way to the end, to the point where let's ring it up on the cash register, write me the check, sign the contract. Okay, I'll do that. Hey, why does it say Whittlefish here? Whittlefish wasn't mentioned up front. If it had been, much different case, much different issue. And that's what I said. If they come in and she had said, hey, we can't deliver for 10 weeks, oh, that's not acceptable. I'm not even going to waste my time anymore.
I mean, both transactions did close. They both occurred in the CFO building.
Absolutely.
Both customers intended that they were purchasing cabinets through CFO, through their employee, Ms. Neal.
And the CFO, I would assume.
What seems to be the only issue here is because the check is written to Whittle. I mean, clearly if it was written to CFO, then she somehow diverted that into her own pocket in some fashion. We wouldn't even be clear as this discussion about it. It's because at some point the term Whittlefish is put on the check.
Her testimony was that it was CFO's policy to tell the customers you're not getting your cabinets for 8 to 10 weeks. Those were her marching orders. Okay, that's fine. If CFO expected her as their employee not to present that and then undercut them with an alternative, she's the salesperson. She's supposed to smooth those wrinkles over. She's supposed to work in some way to still accomplish and close that deal despite that. Maybe I should go into this. I recently hired a company to screen my lanai in the back of my house. And I got an estimate that was outrageously expensive. I got one that was kind of over the road, and I got this one that was the lowest. And I wondered, why in the world would anyone let that low? It was because they had to wait. I had to wait 10 weeks. They were that far out. That's how popular they were. But they gave a lower price. So that's that company doing it, and that's fine. But that's exactly what happened here. If you think about it, Ms. Purcell said, I have to make this work, let's go forward. I got to get a cheaper alternative.
Counsel, what about the second issue? How is the unrelated check? How does that describe the charge? I mean, whether it's harmless error is a different question, but that kind of looks like error to me.
It's not error, Your Honor, because it's not a criminal check. It has nothing to do with this.
You're telling me that when the jury sees that check in the context of all the evidence at trial, that how would every juror not assume that was a third?
Because Officer Hicks testified. I called people after Mr. Troll, the manager, told me that she was committing a theft. I looked into it. I talked to Purcell. I talked to Adams, the lady who wrote that check that was found in the bathroom. Why did you not talk to anybody else? Nobody else answered the phone. So there's other people out there. The jury knows about that. But Officer Hicks said, with respect to Ms. Adams, who wrote the check found in the bathroom, that she gave, I forget the wording exactly, I apologize, but she said nothing of a criminal nature. Okay.
Who's that check written to?
Whittlefish.
There's Whittlefish as well.
Okay. And that's what it was. Because it came to light, that's how it came to light, and that's why I argued it was inextricably intertwined, that the state is allowed to
But that
present how it got
happened
started.
months later, right?
Huh?
That transaction happened months later.
Months later.
Wasn't the check we're talking about in round 2, argument 2, when did that transaction happen in relation to it was after?
Yes, it was after.
So how is it intertwined if that occurred after?
Because that's how they came to light. That's how all of this came to light. And I forget
What case says that how it came to light is how you analyze whether it's intertwined? Isn't it intertwined with the charge?
Shively versus State. It's a 50 CA case, 2000. Held that evidence necessary to describe how an offense took place or how it came to light is generally admissible as relevant evidence, even if it may be bad act evidence, because it is inextricably intertwined. Now, in this case, it's not a bad act. It's not criminal. It's not similar fact evidence. Hicks said there's nothing criminal about that. is not charged, the jury knows that both Troll and Morris, Detective Morris, went in and looked at other customers. Troll did his own internal investigation, then Morris came in after that. They both talked to customers, plural, more than one. The jury knows that there's more of these people out there. Even appellant testified that a lot of customers, apparently in the same position, were being bullied. So she admitted she'd done this a lot. So it's just not. I mean, it just tells how the case arose. And there was a quote, if I could find it here.
Just need to wrap up, counsel.
Yeah. Okay. Simply that I think it was a case that had quoted McCormick on evidence, and the author of that treatise said that the police officer should not be put into a position of having to just either say or intimate that I just happened upon this crime. They have to be able to say something. I did this, and that's what he surmised.
Thank you, counsel.
Sorry, I'm very clumsy. So just briefly, I want to address ground one first. The elements of the crime doesn't consider the intent of the customers. If you look at the jury instructions, that's not even instructed. Second, the customers, I know there was some indication about a fraud on the customers, but they're not the victims in this case. They weren't shown as the victims in this case in the jury instructions, and the state conceded several times in the records that they were not victims. It's page 209 of the trial transcript, and then the record 130 and 132.
So you said the intent of the customers is not an element, but the intent of the customers, argued by the state, is informative of the property interest.
Sure, it's informative of that, but I still say that, under his argument, I still say that once it was written to Littlefish, that cleared up any ambiguity.
So, but the transaction closed at that point. Here's your check. It says Whittlefish, Mr.
Yes.
Magoo, cash, CFO. The transaction closed at that point.
Yes, it closed, and it was,
And then, so whose money was that at the time?
the company made payable on the check.
Because the alleged criminal told them to do that here, even though the people thought they were dealing with.
Well, the point, though, is it never became a property interest of Cabinet Factory. So they never received the cash, a check.
The transaction ended, saying, all right, I agree, I will buy these cabinets. So we now have a transaction, and I'm getting ready to pay. I mean, it's done.
Yes, it's done at that point.
I mean, so they're writing the check, and it's just, you're basically saying the transaction became undone when the term Whittlefish, the transaction with CFO became undone when you put the word Whittlefish on the
I
check.
wouldn't say that the transaction with Cabinet Factory was undone because it was never completed. It was completed with Whittlefish, and that's when they obtained the property interest.
Did your client ever, this sort of argument that we were talking about here with your opposing counsel, did your client ever argue that, hey, look, CFO would never have closed these transactions without, if I wasn't there, if the defendant wasn't even there, CFO would not have closed these transactions? And did your client ever make that argument?
I'm not sure that they did.
Okay.
I can't recall.
I don't think, especially as Ms. McClure, I think Ms. McClure didn't know your client, did she? That they came in, was she the one that came in with her son or something?
Yes.
And they were looking, and your client happened to be on duty working that day, and it's like, oh, okay. Like if I walked into Home Depot and I was looking for something, oh, here's a Home Depot person comes up to me, so I'm dealing with that person. So I mean, McClary certainly was coming in not because she knew your client beforehand and wanted to deal with her directly. It just happened to be Ms. Neal's turn to get a customer.
Ms. Neal offered
She
an
deferred that to
alternative.
to Whittlefish.
I think at that point she offered an alternative, either cheaper or faster, or both. I also want to touch on the point that the state made about every business is in trouble in this state if this is allowed. And I'll point out that they're not actually. There are civil remedies, there are employment remedies, so I don't think that should be a factor.
We probably beat number one to a dead horse.
Yeah, Yeah.
don't count.
Yeah.
Well, I agree with Judge Eisenhower. I'm puzzled about this issue too. Puzzled in your favor, actually. I don't understand how something after the fact is inextricably intertwined to completed crimes before.
As for
Can you
number two.
respond to whatever?
Yeah, I mean, I think I rely mostly on the brief, but I would just add, it doesn't, one point that the state made was that the check wasn't criminal, or it's not a bad act, but I think that a jury could infer that
The
it
identical
is.
check. So they, I mean, obviously different number.
Yes.
They blocked out the number, but other than that, it's somebody writing a check to Miss Neal's company.
Exactly, and I mean, it could also, even if the jury doesn't think it's criminal, they could think that it's still stealing customers and morally a bad act. I believe I'm out of time. Thank you.
Thank you, counsel. All right, counsel, thank you.